Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I have to give you a legal disclaimer. The Florida Bar has said I've got to tell you that this is not legal advice. So I've done my due diligence. But nothing will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games the disability carriers play, and what you need to know to get the disability benefits you deserve. Today, I'm going to talk about chronic headache claims. Now, I get a lot of chronic headache claims, and I want to make sure that before you stop work and apply for benefits or you deal with a wrongful denial of your claim, that you understand some basics. So I'm going to talk about Migraine 101. I'm going to talk about how the court rejected MetLife's demand that a policyholder with chronic headaches produce objective evidence of disability. And I'm going to talk about migraine long-term disability insurance claims and the subjective medical evidence trap that's waiting for you in your disability insurance claim. Let's take a break for a moment before we get started. Welcome back to Winning Isn't Easy. I'm going to talk about how disability carriers will use the subjective medical evidence trap as a way to limit or even deny, terminate disability benefits for migraine headaches. There are a ton of evidentiary traps in migraine claims. And I don't want you to think just because your doctor diagnosed you as having a migraine and said you were unable to work, that the carrier is going to FedEx you a check for your disability insurance benefits. They're more than happy to collect your premium, but like Scrooge, they don't want to pay a dime to pay you the disability insurance benefits you deserve. They often will deny a claim on the basis that there's no objective basis of the diagnosis. But if they are so gracious as to accept that you do have migraines, the next line of defense is to argue that your symptoms are not severe enough and they're not disabling enough to justify the restrictions and limitations that have been assigned. And I think that it's crucial before you stop work and apply for benefits that you understand how carriers can use their policy or their plan to try to bludgeon you into a claims denial or a claims settlement. So the most important clause in one of these cases, I think, is the subjective medical condition clause. You need to get out your disability policy or plan because there's no uniform language in policies in the United States. Open up the policy, look at the definition section or the limitation section. You're looking for the subjective evidence section of the policy. So let's talk about this. What is subjective evidence? Now, that's a bit of a strange question because the answer is right there. It's subjective. When you see the doctor, you complain of symptoms that are consistent with a diagnosis, but you may not present at the time of the examination with a migraine, or you may have other symptoms that are in common with a migraine. There is no objective gold standard testing on examination that will quantify the severity of your symptoms, how those symptoms impact your functionality. So you could complain of a headache, eye pain, dizziness, nauseousness, vomiting, fatigue, or problems with concentration. And your doctor may have a hard time finding evidence, objective evidence on examination that supports the level of your complaints. But nonetheless, your doctor believes you and supports your claim. Now, group disability carriers, ERISA disability carriers like Cigna Standard, and private disability carriers like Unum or Northwestern disregard or even discount your subjective complaints in deciding to pay or even terminating your benefits. I think that it's crucial that the medical evidence be there, but that you also have statements of friends and family members that objectively quantify the nature, extent, duration, and frequency of your migraine symptoms. Now, why would I say that? Disability carriers are going to often minimize the complaints of migraines, and they're going to try to use the one-size-fits-all analysis for a migraine claim. Your level of pain, your discomfort, your disability are personal to you. They can vary from day to day, week to week, month to month. So keeping a pain diary is one way to document, explain, and quantify your symptoms. Your subjective complaints can also be quantified by statements of your family and friends that document the nature, extent, and frequency of your symptoms. And sometimes even video can document the severity of your symptoms. Your physician has got to provide support by explaining why your subjective conditions are consistent with a diagnosis, and they need to complete not only attending physician statement forms, but what I call the migraine residual functional capacity form. I'm a Social Security attorney also, and so I use the residual functional capacity forms in Social Security cases in my ERISA disability cases because they ask the right question. Now, there are also times when I want functional capacity evaluations or neurocognitive testing because that provides objective evidence of your functional restrictions and limitations and how those functional restrictions might meet the policy or plan definition. But what are we going to be faced with at the end of the day? If your policy has a subjective medical condition clause, your benefits can be limited. They can be limited to just 24 months. Now, because there's no uniform policy or plan, you got to get it out. We got to read it. And the policy may say that a medical condition that's subjective in nature or characterized by pain, fatigue, headaches, or problems concentrating are per se subjective and limited to just 2 years. And worse yet, and much harder to get around, is the policy or plan that says migraines are limited to just 2 years of benefits. And if that's the case, then we may have a tough road here. But you can see that you need to understand the policy limitations that can impact your claim. You have to have support for your claim and a plan to try to maximize and extend your benefits beyond 2 years if there is a subjective medical condition limitation. Wow, a lot of stuff we covered, and I hope you understand the significance of understanding what's in the policy, your medical records, developing a plan, and working with an experienced ERISA disability attorney who also does Social Security disability benefits. I hope you've enjoyed this week's episode of Winning Isn't Easy. I'm sure you've enjoyed this episode, so like our page, leave a review, and share it with your family and friends. And of course, subscribe to this podcast. You'll be notified every time a new episode comes out. I hope to see you next week, and tune in for another insightful episode of Winning Isn't Easy. Thanks.